It's exciting for me to have this opportunity to introduce my friend Gene Dubofsky at this particular time in our history and the selection of a Supreme Court justice. For Gene Dubofsky was the first woman to be selected to be on the Colorado Supreme Court, as well as the youngest member of the Supreme Court in 1979 when she was asked to be on the court. She served on the Supreme Court for until 1958, I believe, and until 87. I'm sorry, and since then she's done primarily appellate court cases, and I don't think there's anyone better qualified to speak to the Supreme Court as an issue today and its importance to our lives than Jean in the state of Colorado. After she retired, she's fortunate to have a young grandchildren living within a mile of her home in Boulder. With that, introduce Gene Dubofsky.
Thank you, Gordon. Early this morning, I had something that was nice happen to me, and it's illustrative of your 4 FAQs. I was standing in line to get my usual morning cup of coffee, and as I got close to the front, I said to one of the baristas, "I just heard on the radio that Senator Flake is going to vote yes." And then I got up to pay for my coffee, and the barista said to me, "The man in front of you just paid for your coffee." And he was an Asian American. I went over and thanked him, but I thought, oh my, I don't know whether he was reacting to what I had said or whether he was just part of one of those groups that goes around and does things that are particularly friendly. But I think it was the first. And maybe this is the time right now when we need to work harder than ever to make sure that we're listening to people and that we are civil to people and that we can stand up for what we believe in very, very strongly and still not put others down. I know I felt yesterday I'm going to talk about judicial selection. So here we go on a topic that's somewhat fraught. But I felt yesterday more affected by what was going on in the Senate than I've ever felt about anything. I thought those hearings showed what women have experienced, whether through sexual assault or another way of being put down, as nothing else has ever shown me. And it also showed me how upset people can be when they think they've been falsely accused. And whether you believe that Brett Kavanagh was falsely confused, falsely challenged, falsely criticized, falsely accused, that was the word I wanted, and how difficult it is sometimes for anyone to ever understand whether an accusation like the one against him is true or false. I know that because I saw lots of child custody issues when I was a judge, and it was very easy, one would think, for in an angry divorce, the wife to accuse the father of sexually assaulting the child in order that the wife could retain custody of the child. Or you see it in kids' soccer teams, baseball, basketball teams, when a mother, it's usually a mother who's not very happy, accuses the coach of not favoring her son. And it carries overtones if you're doing something improper. So it's been going on in our society for a long time, and I think Judge Kavanagh reflected some of that. But I also think he demonstrated something about judicial temperament, which is not partisan. The hearings, both of them, the one a couple of weeks ago with the interruptions by protesters against Judge Kavanagh, were not very attractive. And what happened yesterday, particularly with Judge Kavanagh and Senator Graham screaming at the Democrats, was also not very attractive. And it made you realize we have to pay attention to this stuff. We can't let things get this far out of control. But then I thought, well, we've had a long history of contentious judicial appointments. I know because in 1969, I worked for then Senator Walter Mondale. And one of my assignments was to work on then President Nixon's appointment to the US Supreme Court to replace Abe Fortas. He was trying to make Abe Fortas the Chief Justice. I'm sorry, to replace Abe Fortas. Abe Fortas had already resigned because President Johnson tried to elevate him to Chief Justice. Any rate, Nixon first appointed Clement Haynesworth, who was a judge on the Fourth Circuit and was from South Carolina. We're on our Southern strategy for President Nixon right here. At any rate, the vote against him was 45 in favor, 55 against. It was a mix of Republicans and Democrats. So what we now see as being a fairly partisan politicizing of judicial selection wasn't initially partisan. The next one that President Nixon appointed, or tried to appoint, was Harold Carswell, who was a Fifth Circuit judge from Florida, Southern strategy again. That didn't work by about the same vote. So he finally appointed Harry Blackmun, who was confirmed 94-0. In 1987, President Reagan appointed Robert Bork, or attempted to appoint Robert Bork, to replace Lewis Powell. Lewis Powell was viewed as a centrist, a moderate, but also a Republican. That didn't work. He lost 42 in favor, 58 against, but the partisanship was much clearer there. 2 Democrats voted for him, 6 Republicans against. The replacement then was Doug Ginsburg. Ginsburg's nomination was withdrawn because he admitted to having smoked marijuana. Now that sounds sort of quaint these days, but that was his disqualification. And finally, President Reagan appointed Anthony Kennedy. So you can see what was happening in a way, because you were getting moderates if the Senate was doing an oversight that was pretty rigorous, but also beginning to be based more and more on partisan considerations. And I think that reflected what has been a long time coming, which I call the polarization of the political parties. It's not the same kind of Republican Party it used to be. It's not the same kind of Democratic Party it used to be. And that's being reflected in many ways in our society. I should tell you that in the more than 50 years I've been a lawyer, a majority of the justices on the US Supreme Court have been Republicans. I've never practiced law in a court that had a majority of Democrats. But they were moderate Republicans. There were some pretty conservative ones, but for the most part, they were fairly centrist appointments. And I guess my real point is that if a president appoints either a Republican or a Democrat who's viewed as being fairly reasonable and centrist, you won't get fights like you're seeing here. I'd also like to talk a little bit about the role of the Federalist Society. It was an organization put together in the early 1980s in the law schools. I know about it because I was on the Supreme Court for Colorado then, and I kept being invited to speak to the groups either at DU or CU. And I knew how belligerent some of the people could be. I was supposed to be representing the opposite side, and I thought, I don't really need this, so I never accepted. But they weren't dependent upon me. They developed into a debating society, and then people who would go to conferences, and then pretty soon putting together lists of people who should be appointed to judicial vacancies because they all shared pretty much the same views. So President Trump's selections have mostly come from Federalist Society lists. In Colorado, both Tim Timkovich, who was my opponent in the U.S. Supreme Court in the Amendment 2 gay rights case, is the chief judge of the 10th Circuit now. And Allison Ide, who was on the Colorado Supreme Court, is now a 10th Circuit judge as well. And both of them were on Federalist Society lists and indeed were on the list of people that went to President Trump. One of the things, however, that may happen with the Federalist Society is that because the lines are becoming brighter between libertarians, social conservatives, and establishment conservatives, you may see less of a unified position. And I think the Democrats, if they're going to be concerned about appointments to the courts, will have to figure out ways to work together. But Senate approval has been a constraint on presidents when they are of different parties than the Senate, or a different party than the Senate. One of the things about Judge Kavanagh that has been a target, mostly for women's groups, but for a lot of other civil rights groups, has been the record from his opinions. He has written, as a U.S. Court of Appeals judge, opinions against environmental regulations, against gun control, against abortion for undocumented minors, against the Consumer Finance Protection Bureau, against Obamacare, against campaign finance reform, and he wrote that a sitting president should be exempt from criminal prosecution. So you can see why people have been pretty excited about this appointment. On the other hand, the American Bar Association gave him that organization's highest rating, although this morning they came out with a news statement saying the FBI should be allowed to investigate. Judge Kavanagh has a reputation as being intelligent, pleasant, likable, and having a good judicial demeanor until yesterday. And I think that continues to be a worry, not because he won't be able to control himself in Supreme Court arguments, but because he will have left an impression on people that he's not or won't be fair-minded. So what is the impact of his, I'm still certain he's going to be approved, on the credibility and reputation of the Supreme Court? Well, I think he'll have trouble for the rest of his life with this. It's not just that somebody, let's say in a divorce proceeding, accused him of mistreating a child. This is something about as public as one can ever get. And although you won't be able to name all the U.S. Supreme Court justices, most people will remember what they learned about him this month. I don't think he will be able to feign impartiality after yelling at the Democrats, and I don't think he will be accepted by many women. The thing that struck me the most was his condescending answer to Senator Klobuchar, the woman who's a senator from Minnesota, and is generally very level-headed, and she had asked him a question in a very nice tone, and he really unloaded on her. If you've seen that interchange, you will see what women often experience in places, workplaces, social groups, all kinds of things, when they're being either talked over or treated in a demeaning manner. And I thought the use of the female attorney to question Dr. Ford was inappropriate as well. First of all, this isn't supposed to be a trial, and she got treated as if she were on trial. When the senators did not use her to question the judge, then it didn't feel as if he were on trial. And I thought that, again, was something that was pretty obvious to most women. This isn't just about sex assault. It's about a whole variety of things. And it has to do with how people feel, both men and women, about women in places other than solely at home. At any rate, I think for the U.S. Supreme Court, we're going to be left to rely on the Chief Justice, John Roberts. I think he will, on some issues, try to be more moderate because he sees that it's the court's reputation and not just his that's maybe at issue. But let me talk for just a couple of minutes about the judicial selection process itself. The U.S. Constitution basically says that, well, it does say directly, that a judge at any level of the federal court system holds that position upon good behavior. That's the word that's used. And that has been made the equivalent of for life. The Colorado selection process, I'm going to use as an example to show you that there are different ways of selecting people. And in Colorado, the legislature has been removed from that process. Nominating commissions are selected for each judicial district in the state and for the state appellate courts. And the members of those nominating commissions have one more non-lawyer on it than lawyer. The state appellate nominating commission has one lawyer and one non-lawyer from each of the state's congressional districts, plus one non-lawyer. And the governor appoints the non-lawyers. The governor and the attorney general and the chief justice appoint the lawyers to these commissions, and each commissioner serves a 6-year term. People who want to be on those nominating commissions usually nominate themselves, not always. The governor particularly will have a list of people that he thinks are appropriate. Then members who want to be a judge file an individual application for selection. They are interviewed by the appropriate nominating commission, and 3 names are selected and forwarded to the governor. The governor makes his, I wish it also were her, we're not there yet, makes his selection from those 3 names. My experience, however, did end up involving the legislature. There was a legislative hearing as to whether I should have been appointed after I was sworn in. And the argument was that I had been pre-selected for appointment by the governor. As Gordon said, I was the first woman to serve on the Colorado Supreme Court. I was appointed 2 years before Sandra Day O'Connor was appointed to the U.S. Supreme Court. And I served as the only woman on the court the entire time I was there. Some people said I was too young. Some people said I didn't have enough experience. But it was that pre-selected business that people sort of latched onto. And some years later, one of my friends who had been very actively involved with the Bar Association here said, well, you know what the pre-selection came from? Your husband told someone he thought you'd be appointed. And so you were pre-selected. I thought, well, that was because he loved me. What else was he going to say? At any rate, the legislature subpoenaed members of the nominating commission to come and testify as to whether anyone had approached them about selecting me before the nominating committee met. And they got nowhere with that effort because nobody had approached them. At that point, the whole selection process was confidential, and the names, not even of the other 2 finalists, were released. The process now involves extensive lobbying of members of the nominating commissions. I see that as being somewhat ironic, but that's how things have devolved. So members of the nominating commissions get lobbied but they still operate in the same way without any legislative involvement. And I think my appointment was the only one that has ever had a legislative investigation of whether the nomination was appropriate. Some things haven't changed, but one thing has. There have been 2 Colorado Supreme Court Chief Justices now, and most of the time there have been 3 women on the Colorado Supreme Court. And that makes a huge difference, because when you're the only one, then people look at you and say, well, that's the woman's point of view, as if all women think exactly alike. And I'd like to conclude with just mentioning a couple things about how we might change the federal for-life nomination process. One would be to have a mandatory retirement age. And if you think of the people who are pretty old on the court, who do you think would get removed by that? So that isn't always very satisfactory, but it does say that the membership of the court will change over time, more quickly over time. And you might be able to make that choice with a statute interpreting what good behavior means. After you reach a certain age, you can no longer be considered to operate with good behavior. I think that's a stretch, but otherwise it's going to take a constitutional amendment, and I think that's pretty unlikely. One thing that I think would take a constitutional amendment is another suggestion that I've heard about several times. That would be to give U.S. Supreme Court justices, and probably federal appellate and trial court judges, an 18-year term. And then if you're looking at the Supreme Court, each president would get 1 appointment per term. And that would turn membership of the court over, obviously more frequently. And it also would allow the court membership to respond more closely to views of the public in general. I think we're going to be faced with a very conservative Supreme Court for quite a while now. And I think there's going to be a lot of controversy around some of those decisions. If we'd had at least the last one, and maybe the last several, as more moderate appointments, I think we'd be in much better shape, because it's pretty hard to think that a Supreme Court that rules on lots of important issues is going to be impartial when it's gone through such a politicized process as we've just had. And I would be happy to answer any questions anyone has.
Jane? Well, I think we probably have some questions. Are there questions in the audience or not?
It's been suggested that Roe versus Wade may be overturned, and I'd just like your thoughts on how the process that we're seeing now might lead to the overturning of Roe versus Wade, and how that would look.
Well, I think the first thing that might well happen is that Justice Kennedy voted for the opinion that the U.S. Supreme Court issued a couple of years ago, not allowing restrictions on abortions at the state level, which made abortion much less available. And I think we'll begin to see a lot of court decisions challenging the ways in which abortion is now available. Each state does it slightly differently, but for the most part, there have been some pretty clear restrictions that were basically set out in Roe versus Wade. And we've been chipping away at them a little bit, haven't gotten very far, but there's some lower court decisions that could come to the Supreme Court right away. And I think that's what's going to happen. I'm not so sure that Roe versus Wade will actually be overruled, but I think its breadth will be pretty severely limited. And where the problems will be greatest will be for women who live in the states that have already started to adopt restrictions on the availability of abortions. Yes.
Do you also think that if, with your idea of the 18-year idea, that the judges need to be removed or get new judges, does that have to be a constitutional amendment, or could that be done by legislative sense?
I'm sorry, which one did you say first?
For the 18-year
Oh, the
idea.
18-year one. I think that would take a constitutional amendment. I don't think you could say anything beyond 18 years was a lack of good behavior.
And do you think it also should apply to the states? Do you think the states should also have the same idea of a...
Well, every state has such a different way of appointing judges now and different requirements. In Colorado, there is a mandatory retirement age of 72. So, and the way the turnover on the Colorado Supreme Court has worked, because each justice gets a 10-year term and then is before the voters, there are already some ways of getting rid of someone you don't like, or making a difference in terms of how long someone can serve. You're not going to have, 3 or 4 80-year-olds on the court.
So a quick question, Jean. It's an if and a then. If Kavanagh does not get, it becomes a Bork kind of thing, he does not get the number of votes needed, and so he's dismissed. And then you're looking at the interim period after the elections before January. Is there a possibility, it is a window, so is there a possibility that another similar person from the Federalist directive list could be brought through very quickly without, what is that possibility?
Well, that's a very distinct possibility. I read somewhere in the paper, maybe most of you saw it, that earlier this week, when Judge Kavanagh's nomination was looking as if it were in trouble, the Republicans were busy starting to interview and talk with people who were on the list who hadn't already been selected. They were going to get the president to nominate one of them right away and start the process. And of course, it'll be mid-January before a Democratic majority in the Senate could vote on one of those nominees anyway. So they've got plenty of time to get another person through. They may come with someone who isn't quite as overtly to the right, who won't have quite as many decisions that are causing problems, and who won't have a history of participation in Republican politics for as long as he has.
I first wanted to thank you for being here and speaking to us. I really appreciate it. My question has to do with partisanship.
Yes.
And how this has become very much in the limelight. It reminds me a lot of our use of the language tribalism when it comes to the Middle East, or nationalism in the past. How can we avoid strict partisanship in the future? How can we get more moderate, centrist people away from the fringes? I grew up in Oklahoma, and I see people I'd rather not go into.
It's tough. I actually am going to Topeka, Kansas, end of this week. That's where I grew up. And I just learned that President Trump is going to Topeka, Kansas at about exactly the same time. And I thought, oh dear. But I think it's very hard. But I also think a lot of people are beginning to realize that elections do make a difference, and that we need to be more careful about how we treat other people. We need not to base everything, all of our judgments, on one's political views. It's perfectly possible to have a wonderful conversation with someone and not mention politics, and just wait until things kind of simmer down a bit. I think they ultimately will, but that's sort of the Pollyanna-ish part of me.
Jean, would you say a few words about your experience in arguing Romer versus Evans before the U.S. Supreme Court?
Okay, I'll be really brief about it. In 1998, I argued the case against Colorado's Constitutional Amendment 2, which prohibited LGBT community from having any rights whatsoever. No protection in the courts, no protection from legislatures, local governments, anything. I don't know how many of you remember our Amendment 2, but it was pretty awful. And the Colorado Supreme Court, after a 4-week trial, had said that it was unconstitutional. The U.S. Supreme Court took the case, and I had represented the plaintiffs all the way through. The argument itself was, I was very worried about it because it was the first time the U.S. Supreme Court had had a gay rights case since a terrible decision about 10 years earlier. And going into the argument, the other side had argued first. Tim Timkovich was representing the state, and he started his argument, and about 10 seconds in, Justice Kennedy interrupted him and said, "Has there ever been a law as bad as this one?" Well, there was our fifth vote. And from then on, the argument became a lot easier. But I think what Gordon's referring to is that in the middle of the argument, somewhere along the middle, I was asked 50 questions in 30 minutes. Justice Scalia asked me where in the record the Colorado Supreme Court had interpreted the meaning of Amendment 2. There is a rule in the U.S. Supreme Court, the interpretation of state statutes or state constitutional provisions, Amendment 2 was a state constitutional provision, are left to the state Supreme Court or the state Court of Appeals. And we had an appendix, it was about this thick. And that was what Justice Scalia was pointing to when he asked me where in the record did the Supreme Court rule on your interpretation of the amendment. And for many years, I'd been arguing appellate cases, and I always wrote down on the margin of the front page the page numbers for important things. But never had I been asked that question. But luckily, I'd written it down, and so I told the court it was page whatever it was, way back, well, not way back in the poem, but about in the middle. And so everybody bends over and opens their books looking for it, and Justice Scalia starts reading something, and I interrupted him because he'd been pretty hostile. And I said, no, it's the sentence before that, the one that begins, at a minimum, Amendment 2 means. And it was a very broad interpretation of the meaning of that amendment. The state, represented by Tim Timkovich, the state has to defend constitutional amendments, whether the state's in favor of them or not, had argued that Amendment 2 was like the provision in our state constitution that says English is the official language of the state of Colorado, that it meant nothing. Nobody was ever going to do anything or enforce it or anything like that. And so the Colorado Supreme Court's interpretation of the broad sweep of the amendment, and it was quite broad, controlled. So those are the two things I can really think of that were dramatic. The courtroom was packed. And if you've ever been in the U.S. Supreme Court courtroom, it's a quite small room. And everybody, whether you know the person next to you or not, those chairs are squeezed so close together that everybody's shoulders touch. Anyway.
Gene, I don't know whether anybody told you, but at Boulder Rotary, we get the last word. And I think they tried to find somebody that was older than dirt to talk to you. You and I go back a long time.
Well,
You were a lot younger than I was and still are. But in any event,
I don't think that's true, but that's all right.
In any event, I want to thank you for your presentation. I've had the privilege of talking to people in probably 24 other countries about our judicial system. And one of the things I routinely tell people is what a privilege it's been for me to practice in the state of Colorado because of judges like you and Mo Sandstead and others, not only in this district, but throughout the state. You talk about our judicial selection system. That judicial selection system is a model for the world. We bring people in from all over the world to study the Colorado judicial selection system. And it's because of the high quality of judges we've gotten, led by pioneers like you, that makes that system really a model for the world. So thank you very much for your talk. thank you very much for your service on the court. And in your name, Boulder Rotary will donate 100 doses of polio vaccine to our fight to end polio. We're this close, and with these 100 doses, hopefully we can get a little bit closer. Thank you very much.
Thanks.
Thank you, Gene. What an honor to our club that someone of your intellect and stature would come and speak to us today. It's so timely. So thank you very much, Gene.